I've had plenty of experience before the microphone, so I know how they work. Okay, it's on? Great. Okay, we'll call the Tremont Planning Board meeting of Tuesday, January 14th to order at 6:01. Roll call, we have Renee Hodgson. Renee, way down there. Feel free to move down if you want. Beth Gott, Ben Harper, myself, Mark Good. Our new CEO, Angie Chamberlain. Welcome, Angie. Glad to see you on board. Our town manager's here too somewhere. And members of the public and applicants. And the attorney representing us, Mr. Lyons. Okay, we have a quorum. I don't see any need to change the agenda. Minutes. I do see an issue with the minutes. John did these, and I think he cut and pasted because if you look under call to order, it says delay by 3 attorneys in conference. I think that was from a previous meeting back in October. So we should strike that. That's the only thing I saw. Did anybody else see anything? Okay. If that's the case, I'll take a motion to amend the minutes to strike delay by 3 attorneys in conference. Motion and second to amend the minutes to strike that sentence. Any discussion? Hearing none. All in favor? All right. Old business. Remand from the court on the Pointy Head Campground. We do have a quorum, like I said. Does anybody feel they have a conflict of interest in this matter? Okay, I guess not. One thing the court was asking us is whether we wanted to accept new evidence or not. We could, we have 2 choices really. We could vote on that now, whether to accept it or not, or wait until we hear from the applicants and the abutters and such, and make the decision at that point. What's the pleasure of the board?
I see we'll wait until we hear from the attorneys and the applicants, and then to make a decision on whether or not we'll accept new evidence or not.
So you say we should just wait and make a decision. Is that the consensus here of the board?
Sure.
Patrick, we don't need a motion on that, or do we?
It wouldn't be, I mean, procedural matters are typically the chair's purview, but if you've already told them, might as well.
Yeah, I figure we're all set. Okay. Okay. Kind of laid out a procedure here for tonight. At first, maybe we'll let the Mr. Bearer for the applicant speak, and then the planning board and our CEO can ask any questions. And we'll have Mr. Pelleggi, who represents the abutters, respond, and then we'll allow him to speak, and Mr. Bearer can respond, and we can ask him questions as well. And then we'll allow some public comment, and hope everybody keeps things brief. 3 minutes or so would be great. Mr. Bearer?
Thank you, Mr. Chairman. I'm disappointed, obviously, that Mr. Witham isn't here. I think he was the lone board member who kind of saw things our way on this issue last time around. But I'm glad that the new members have had a chance to review the record. Sorry if you having to do that, but it's been done, and I guess we'll proceed tonight with the 4-member board. What I'd like to do is just start by explaining what I understand anyway, and you can get opinions from Mr. Lyons if I'm not saying anything incorrectly. But basically, in this country, a person has a right to do what they want with their property. Or at least that's the way it used to be. Back in the 1800s, late 1800s, towns and cities began adopting ordinances that regulated uses, where you could have a house, where you could have a factory, things of that nature. And built up around that has become this world that we know of now, where every town, virtually every town, has zoning ordinances that regulate uses and things of that nature. And the purpose, as I would understand it, and the objectives that are spelled out in your ordinance, and I cited them in the materials that I submitted back in September or whatever it was, is to protect X, Y, and Z. Actually, in your case, it goes like A through N, all these different things that we're supposed to protect through these ordinances. And you met every one of those standards, as far as I can tell, because you have an ordinance that says we want, the objectives are to protect X, Y, and Z, or A through M, whatever it might be. And this board found that we met every one of those standards. Every one that you could possibly throw at us as a campground, we met. The only question was the access way to this property. And I'm perplexed that there's anything that your ordinances try to protect that would be compacted by using an existing access way. It's not being paved, it's not new. In fact, by your ordinance, it has to be an existing trail or road. So, and I think the court was a little perplexed by that too. I know that there was discussion amongst counsel and the judge that, you know, what are we protecting here in the commercial fishery and maritime zone on the other side of Route 102A? And we know, we've all visited this property, and we've put in the trees that you wanted to put in. We had the most extensive wetland study that I think probably you've seen in a long time done, et cetera, et cetera. So, I think as a perspective, I don't know what it is that is being protected by a decision that prevents my client from using her existing access way to get to this campground that you found met all the standards otherwise applicable to such a use in that zone. But I'll deal with the ordinance as it's written, deal with the court's order as well. From my view, and your view may be different, but the ordinance allows, as permitted uses, trails and roads. Okay, trails over here on one end of the description, and roads for use by motorized vehicles. I think the use really is motorized vehicles. We get all caught up on this notion of, is it a trail? Well, you know, you don't define trail in your ordinance, but if you go to the dictionary, it could very well be considered a trail. Is it a road? Well, it could very well be a road when you look at the definition of road in your ordinance and you see that it's described as, you know, being created with macadam, pavement, or dirt, etc. It's plain, but that's all there. The court even found that the parties had agreed that it was a road, I believe. Let me just find that for you. In the court's order, the parties agreed that at least until 2001, when the three-story building on the property ceased operation as an inn, the existing way was properly considered a road. Parties agreed in front of the judge that as of 2001, that use ceased, it was a road. I think the way we got here is because when Madeline started using the property, she used it as her residence. But I don't believe that changing that use changed the use, which has been characterized as a road by the court, and agreed to that by the parties, that previously existed. There's nothing in your ordinance to suggest that a road can't be the access to a house. We got all wound up or wrapped around the axis, so to speak, when we concluded that, a driveway is defined as something that's less than 500 feet long and goes through no more than 2 dwelling units. Well, before it was a dwelling unit, it was an inn that the parties agreed in front of the judge was a road. The access way was a road. And I don't think changing the use of that property, the residence on the property, or the building on the property to residential, changed the thing, the access way, from the road to a driveway. That doesn't make any sense. I don't know why anybody could conclude that. I think it's a road. I don't think that it's a driveway. It's something that's being used by motor vehicle traffic, which is what the ordinance says the use is, use of a road or trail for motorized vehicles. So it's a red herring to go down this road about it being an expansion of a non-conforming use. A driveway, it's not a driveway, it's a road. The road is not a non-conforming use. A road is a permitted use in that zone. You could also argue that it's a trail. It fits the definition of trail as well, when we look up the Webster's Dictionary. And with respect to whether it is or whether it isn't a driveway, your ordinance defines a driveway as being 500 feet or less long. I provided you with a document that this access way that we have constructed, the existing way and the access way that was built onto it for our proposed use, 502 feet. So 502 is more than 500. Driveways can't be more than 500 feet. So by definition, this is not a driveway. That's pretty straightforward. So, as I was thinking about this further today, I remembered a case from the 80s, the 1980s, not the 1880s. And it's called Your Home Inc. versus the City of Portland. And although it's a 1980 case, it's still good law. It's been cited a couple of times since then for the proposition I'm going to discuss with you. So, in Your Home Incorporated versus Portland, the developer wanted to have a mobile home park in a particular zone in town. But that zone didn't mention mobile home parks and the uses. It talked about single-family dwellings. And the court held as follows. Please listen. The name by which a building, in this case a mobile home versus stick building, a building or use is designated by the ordinance or called has some evidentiary value. In other words, is this a driveway or a road? Well, there's some evidentiary value there if you want to try to parse that. But is not of controlling importance in determining whether such a building or use is within one of the permitted uses under the zoning ordinance. It is rather the nature or the character of the use to be carried on which will settle the construction to be given to the ordinance language. I'm going to read this again in a moment. But what the court is saying there is similar uses, you have an obligation. Your ordinance does not say, some do. Your ordinance does not say if a use is not listed here, it's prohibited. It doesn't say that. In the absence of that type of prohibitive language, you have an obligation to examine a use that is similar to something that is allowed in the zone. Trail, road, driveway. Somewhere between those two descriptors of trail and road, I submit to you, is a driveway. Now, with that in mind, and bearing in mind that the topic in this case, Your Home versus Portland, was residences, mobile home park, single-family dwellings. Court held, the name by which a building or use is designated or called has some evidentiary value, but is not of controlling importance in determining whether such a building or use is within one of the permitted uses under the zoning ordinance. It is rather the nature or character of the use to be carried on, which will settle the construction to be given to the ordinance language. The use is not so much the road, the trail, or a driveway. The use is the passage of motorized vehicles. That's what's allowed in this commercial fishery and maritime zone over roads and trails. Your burden is to say, well, how is it manifestly different to access the property over something that we conclude is a driveway, you, not me. you conclude it's a driveway. Is it manifestly different than passing over with motorized vehicles over the road or over a trail than it is over a driveway? That's for you to decide. The court says that it's your obligation to decide. Bear with me, please, because I don't see all that good. I'm reading from the same case. Portland, Your Home Inc. versus Portland. The similar use formula of the old ordinance was not necessary. Portland used to have a provision that said, and similar uses are allowed. The similar use formula of the old ordinance was not necessary to provide the board with basic power of interpreting the ordinance. Even without the similar use provision, the board had the power and the responsibility to interpret the ordinance in a rational, non-discriminatory manner. Any use which is similar to and no more objectionable than the uses expressly permitted in a zone and concerning which there is no explicit provision in the ordinance, excuse me, no explicit provision in the ordinance may not be arbitrarily and irrationally excluded from that zone, nor excluded on some ground that has no foundations in the ordinance. But I think that that's your hurdle. If you're going to tell my client that she doesn't have a right to access a campground over an existing access way on her property, where the ordinance specifically allows motorized vehicles over trails and roads, you're going to have to meet that standard, which is a pretty high standard. You're going to have to come up with a really compelling rationale for not doing so. Thank you.
Board members, any questions of Mr. Bear? Angie? Mr. Bear, you maintain that the access way is 502 feet, but that includes a parking lot, a sizable parking lot. Why do you think a parking lot is part of an access way?
Because in order to get to the last two cabins, you have to go to the end of that parking lot. So you drive to the end of the lot and you park in front of that cabin. It's going with me. That's why it's 502 feet.
But the length to the beginning of the parking lot is more like 330 feet.
A lot of roads, driveways, whatever you want to call this thing, go through parking lots. I don't think you say that the road ends if you continue to drive 100 feet, 200 feet, 500 feet with parking spaces available on either side. We had to show an adequate turnaround and all of that stuff, so I don't have a problem saying it's 502 feet.
And I know that what you say about the parties agreeing that it once was a road is in the opinion, but this board has never determined that, correct?
Well, this board was a party in as much as the town was represented at this hearing. It wasn't just Mr. Pileggi and someone from my office, it was the town as well. And if there had been disagreement among council to the court wouldn't have said that the parties agreed. Parties include the town.
Frankly, I'm not happy. I think we had ineffectual counsel during that whole procedure. Somebody with no land use experience was thrown in at the last minute and never consulted the planning board or the code enforcement officer. So I really don't know how they came to that conclusion, but.
Well, Zach Grandwine, who represented the town, along with Mr. Collier, who they both participated, was a very good lawyer. But I'm not here to defend him. You have your opinion. That's the way the cards were dealt.
Anybody else? Mr. Pileggi, would you like to respond to Mr. Bearer?
Thank you. Thanks for listening to me. I apologize. I had a really long mediation earlier today, and even though my wife is a vocal teacher, I don't listen to her, I didn't support, and I've lost my voice. I'm gonna keep.
How long you been married? You should know to always listen to your wife.
6.5 years. And I've gotten it wrong for all of them.
Go ahead,
I
I'm sorry.
want to start with a reference to the record. By the way, my name is Daniel Pelleggi. I represent some of the abutting property owners to this project. Page 47 of the record, the initial application, buffer landscape plan. I want to point out, if you look at that record and the photo that's with it, part of the 502 feet and the gravel parking area that they're counting don't exist. They're not there because, as Mr. Bear just told you, they were built during this process to serve the proposed use. You can see, this is not my picture. This is not my buffer landscape plan. It came from Head of Fine Engineering. It was part of the application. Again, record page 47. And you can see that the area that, you can see where there's an outline to the new proposed parking lot that's now a gravel pad and has gravel access that shows on the subsequent plans. It's green. It's not there. I'm going to argue in a minute that a parking lot doesn't count as a road or a driveway or an access way anyway, and I'll point to to ordinance references to discuss that. I just want to point out, when we're talking about facts, green grass is a fact. So, I don't want to spend a ton of time on this. Your voters, the voters of Tremont, voted, they enacted an ordinance. The ordinance protects the shoreline zone. Whether they wanted to or not, they had to because the state mandates it. And you have several levels of protection. It's a special area within the shoreline zone that the state mandates, and now the town mandates is protected. You have the commercial fisheries, maritime activities subset of that protection that allows traditional maritime activities to take place in areas that are otherwise protected resources. That's your ordinance. That was what the voters decided. This access way goes through that area. The residence, Ms. Brogdon's residence exists in that area, and it's not allowed. It is a lawful, non-conforming use. It was there before the ordinance was enacted, and it's allowed to remain there. But if it were new, if somebody applied to you to build a house where that house is located, they can't do it. If they want to build a marina there or a boatyard or something like that, they can, but they can't build a house there. A driveway to a house is not an allowed use in the CFMA zoning district. An access way to a marina or a boatyard would be. That's what the ordinance says, and we're charged with, you are charged with enforcing the ordinance. So driveway and road have been defined to death. I've submitted materials that show you the distinction between driveway and road. One goes to a resident, not more than 2 residences, and one goes to everything else, basically. Trail, Merriam-Webster says it's a track or a trail through the wilderness or mountains. Mr. Bear says that that's the same thing. It doesn't look, I drove by there again today, doesn't look wildernessy or mountainous to me. So we're down to driveway or trail. Now until the last—
I think you mean driveway or road.
Driveway or road, excuse me. Thank you for reminding me. So until the last time this board was going to meet, the applicant maintained that its plan to use the pre-existing access way was less than 500 feet. SK1 is their driveway plan. It appears throughout the record that you have read in a number of locations, page 368, page 468, and a couple of other locations. Less than 500 feet. Their early materials, including their application, repeatedly refer to the access road as a driveway, which is a defined term in your ordinance. Head of Fine Engineering is a fine engineering firm. They are charged with and understand your ordinance terms, and I would submit they use that term on purpose. The applicant, up until now, said it didn't matter. It doesn't matter what you call it, because the Attorney General says that you can do whatever you want. So you can use our driveway because it's an existing access way. That's what they argued. This board found otherwise. It's only now on remand, when they're talking to you again, that they contend that this road is 502 feet. Now, your land use ordinance, section H, Article H, section 1, C, and D, regulate parking bays and parking aisles differently than roads, differently than driveways. An aisle is and by the way, if you look at the site plan here, the area in the parking lot that the applicant now contends is a road was called a 38-foot wide aisle in the parking area. An aisle is an area to allow people to get in and out of parking spaces. Parking spaces are defined. Article 6, Section I defines and regulates roads and driveways, completely separate. The site plan application contains parking lot layout, 1 space per guest room, 1 space for every 3 employees. They refer to the area that they're now contending as part of the 502-foot road as an aisle. It says the word aisle in the site plan application. So this isn't a do-over. This isn't an argument about what the purpose of your ordinance is. It's not an argument about 1800s law and people being able to do what they want with their property. This is a remand to you guys to make additional factual findings about what's on the ground. And what's on the ground under your ordinance is an access way less than 500 feet. It goes to 1 single-family residence. It is by definition a driveway. It is by definition under your ordinance a lawful, non-conforming use. It goes to a residence. Expanding that to a commercial use would by definition change the driveway to a road. It expands the use to a road. That's not allowed. That's what you found before. In terms of what's there and what meets how the definitions are met, I think that the record as it exists contains all the evidence that you need to agree that, to support your previous finding that the access was a driveway. That's what they called it. That's what they called it all the time up until now. It's what it is. It's what the Plan SK1 said. And it's approximately 300 and some odd feet long. Goes to a single family residence. So your previous ruling where you found that the expansion to a road wasn't allowed is supportable. I gave you a set of proposed factual findings to try and be helpful. I'd ask you to please consider those as you go through the evidence and written submissions and our arguments. I think that everything I've given you in those proposed findings is supported by a record reference, reference to a page in the court record or to a plan, SK1, for example, the site plan. Thank you for your consideration. I'm happy to answer any questions. I'm sorry for taking so long.
Board, any questions? Angie? What were you saying about the aisle?
Yeah. So in discussing the difference between roads and how your ordinance treats roads and parking areas,
Yeah, they're separate.
yeah, so in your land use ordinance's regulations of parking areas, it has definitions for both aspects of a parking lot, basically. The spaces the cars park in,
Right.
and then the space between them to get in, the access to get in and out, calls it an aisle.
Okay.
As opposed to a road or a driveway. And in the site plan application, the initial site plan document that was provided when Ms. Brogdon applied, it referred to the area between the parking spaces that they're now calling a road. They defined it, it says aisle, 38 feet wide. And for a page, if it helps to have a page number, I think that is, excuse me just a second, I apologize. I think it's in the site plan. I think it's 41, thank you. Anything else?
No, Beth, you? No, I think I'm satisfied for now. Mr. Barrow, do you want to respond to
Sure.
Mr. Pelleggi?
And I also want to make clear that during the public comment, Ms. Brogdon wants to address the board.
Sure.
So, what didn't you hear? You got no explanation, no response to the law court's admonition to you that you have to examine similar uses and you have to have some rationale for why that similar use would not be permissible unless it's prohibited and your ordinance doesn't prohibit it. So it's a big, big hurdle for you all to clear. He read you half of the definition or slighted the definition of a trail because a trail is defined, and I think that Ms. Brogdon's going to tell you this, and it uses the example of through the woods or mountains as especially, but not exclusive. So bear that in mind as well. As for the distance, the document that I filed in October was nothing more than the same document that was filed with our initial application, except that our surveyor, Mr. Stewart, measured it from the road, 102A, to the end of our parking area, which we contend is the continuation of that road or driveway. That's all that is. So that document is also in your record, and that document has not been altered whatsoever, and it says 502 feet, according to Mr. Stewart. Now, you can, I think by common parlance, we would refer to the access way to Madeline's property as a driveway. That's common. That's what our engineers did. Mr. Pelleggi wants you to say, yes, but they knew specifically what they were saying and what they were doing, because they're good engineers. Well, we got an opinion, as you know, from the Attorney General's office, from an attorney there who advises the board, the Department of Environmental Protection, whose model ordinance the town of Tremont adopted that has this language in it that we're discussing. And he advised that it's okay under the ordinance to use that driveway. He calls it a driveway.
I think he called it a road.
He called it a driveway. Look at it, but look at his letter. Now, I know you didn't like the fact that you got that letter, but he used the term interchangeably as well. So I'm going back to what I said initially. You got the trail over here on the horizon of what's within the scope of a trail and a road. And I suggest to you that a driveway falls somewhere in the middle. It's similar to, your ordinance doesn't prohibit similar to uses. So we are entitled to use that access way to get to our property. And by the way, Mr. Pelleggi referred to it as a road at one point too. Thank you.
Mr. Lyons, should we allow Mr. Pelleggi to respond to that, or?
I typically let the applicant has the burden and they get the final word. So I
Yeah.
think it's probably there. And it's your discretion if you'd like to hear from them, but I think in the end, the applicant should have the final opportunity to speak before public comment.
Board members, questions?
As I understand it, if they had applied within the year after the inn was no longer, this would have been permitted?
You mean the campground?
No, once the inn had,
They
they
had-
sold the inn.
Yeah, if you look
So
at,
somewhere in the record that they had a year, and then after that year, that use would go away.
right,
So if they had applied.
that would have been for the inn or the bed and breakfast only. They were never really, they were
So
licensed as a
would that
bed
have
and breakfast.
allowed a campground with the use where it had been a business before, an inn? Would that use have gone to Ms. Brogdon for the campground? within that year.
No, nobody would.
Well, that's a change.
Mr. Lyons will answer that.
Well, so, just want to clarify, is this a question for Attorney Bearer, or is this,
Well, this is the question about the ordinance, our ordinance.
well, I think, so, I think, rather, so right now, I would reserve just questions for the parties,
Mhm.
and then public comment, and then once public comment is gone, then this type of discussion about ordinance interpretation, is probably the most appropriate time to do it, so, my advice is, you know, if you don't have any further questions for the applicant or the applicant's counsel, the planning board allow for public comment, and then once that's done, close the public hearing for, close it to further comments from the parties or the public, and then the planning board will deliberate, and we can get into that question. That works for the chair.
Now, do we have to make a decision tonight?
Yeah, probably. Yeah.
We're making great time, so I think we're all good.
So far, so good. Mr. Bear, Mr. Plaguey said that the parking area had been expanded. Can you respond to that, please?
Yeah, it did not. When we filed this application, and you have Mr. Stewart's survey work, it's at the very beginning of our application packet, and you have a small version of that attached to my memo in September. That shows you exactly what was on the ground at the time, where the 3 cabins were that we had placed at an earlier time, and where the parking area and extended driveway, extended road is. That was all there when we filed this application. Mr. Stewart's plan shows those things.
Mr. Plaguey, can you bring up the drawing that you had? It was difficult to see from here. Pardon? Before you were on the board, yeah, it was like 2020 or whatever. Thank you. Anybody else? Renee? Thank you. I guess we'll open the meeting to public comment now. Like I said, please be brief, 3 minutes or so, and state your name if you want to make a comment.
Hi there. I'm not involved in the subject of all of this, and I want to thank you for the 5 years you've given me on this project. I'll try to keep it to 3 minutes. When I started this, many years ago. My vision was to do something with my property. When I purchased the property, it was a business. It was a bread and breakfast and an antique shop. We failed that. Because I had the sign still pointing ahead, and there was an antique shop attached. And I was going to continue some type of business. I even kept the phone number for the pointing head inn. And I decided that, I'm not really an innkeeper. I don't think that's going to fit. So it took me a long time to come up with what I wanted to do with the property, because in total I have over 19 acres there. I finally came up in 2019 and said, from all of the people around here that were having Airbnbs, I said, and I heard about them turning little outhouses, almost shacks, slap a bed in there and somebody come up and spend the night. So I said, well, I'm gonna try that. I apologize that I didn't get the right permitting. I was ignorant of the law. Where I come from, I start businesses. Some of them made it, some of them didn't. So I ventured out and tried something as an experiment. It worked very well. So then I was going to proceed, but then by that time I found out I had not gotten building permits. I had to go to the planning board. So all of this started. We got it, as my attorney told you, everything has been approved. I'm on an approved campground. If I were not in a maritime zone, the first part of my front yard, I'd be in business. But because I happen to be in the maritime zone, the front, nobody can drive through. So I don't have access to go back and have any businesses ever on that property unless I become a lobsterman or I start building boats or making buoys, and that's not what I can ever do. I'm going to start by going through some documents here because I've gone through the file. And it seems that we're now in court, and the first page of what has come back from Judge Duddy says that the planning board failed to make sufficient findings of fact to allow for meaningful judicial review. So that's why we're here. The planning board needs to do a little more homework. So I went back, and starting in 2020, which was when I started interacting with the code enforcement officer, Jesse Dunbar reached out to Legal Services Department. This is an email that he received from them talking about that I had some shoreline zoning issues. And I will read you exactly what they said. Since the ordinance is not clear, I will defer to the DEP's judgment, since it is the department's responsibility for administering the shoreline zoning rules and specs. If this were to go to court, a court would generally give deference to the DEP's interpretation of the ordinance and state law. That's the Department of Environmental Protection. But I was denied. So my attorney went to the Office of the Attorney General of the state of Maine, who oversees the DEP. And he wrote back, and I will quote from his letter. He says, the land use table of Tremont, under the number 2, that vehicular traffic on existing roads and trails is permitted without a permit in all land uses. Well, I remember, Mr. Good, you said, state of Maine doesn't tell Tremont what to do. So I was denied again.
I never said that. I'm sorry.
I heard it. I sat in this audience. I heard it.
I don't want to argue with you. Okay, go ahead.
Your definition of a driveway is a vehicular access way less than 500 feet. Okay? We're 500, we claim that we're 502 feet. Your definition of a road is a track consisting of a bed of exposed mineral soil, gravel, asphalt. This sounds just like my way, my trail, my driveway, whatever you want to call it. This is exactly, it's made up of a lot of things. It says it's a track. Your ordinance says that trails are permitted. The judge asked what Webster's dictionary definition was. And Webster's dictionary says a trail is a track made by passage, especially through a wilderness. And somehow I read something that Mr. Pelleggi pointed out that I don't have a wilderness on each side. You're right. But the word says especially, not exclusively, and there is a difference, just especially. It was a road. You don't want to grandfather it to be a road. I think it's a road. But you know, there are a lot of establishments in Tremont. We can start with my next door neighbor. That same maritime zone goes right in front of his yard. And yet people drive in to access his rentals that are advertised on VPRO. We went through VPRO, Airbnb, and Booking.com. We have almost 20 shoreline rentals within 250 feet that are in maritime zone. There's a campground that has gone up on my road, not in the maritime zone, but is in full operation. The first, the argument was that it was a campground. Now I'm okay as a campground, but I can't access it.
Ms. Brogdon, could you sum up, please?
I will. The conclusion from the judge says that the matter is remanded to the Town of Tremont Planning Board to make findings of fact, accompanied by an analysis and determination of whether the existing way Brogdon proposes to use as a campground is a road, a trail, or a driveway. I do not believe it is a driveway. I don't believe it is I do believe it's 5 to 2 feet. It is a trail by your ordinance, and by Webster's dictionary, the trail is also a road. All I want is to be treated. I follow the law, be treated legally, rationally, reasonably, and fairly. That's all. Thank you.
Thank you. Anybody else care to speak? Mr. Kaufman, please identify yourself.
Yeah, I'm Jim Kaufman. I live over on 36 Bass Harbor Woods Road. I'm a butter, and I've been following this process ever since it began 5 years ago. I won't say very much. I just want to appeal to your common sense. That seems to me that we're here for one purpose and one purpose alone, and that is to find whether this is a driveway or road.
Could you speak up just a little bit, please?
Yes. So there's only one purpose to be here, right? And that's finding a fact. Is this a driveway, a road, or a trail? And I think Dan, our attorney, Mr. Pelleggi, has laid out very clearly why it's a driveway. I would just appeal to your common sense. That if you've driven past there and you look at it, it's a driveway. It's not a road. There's no street sign. If I look at my map app, I can find all the roads. They all have names. It shows driveways as well. So I don't think you need to use pretzel logic here to determine whether it's a road or a driveway. It's a driveway. That's all I have to say.
Thank you.
Deneen Welsh, 32 Bass Harbor Woods Road. I have a very long property line with Ms. Brogdon. Simply, I find Mr. Barry to be consistently dismissive of you as a board, and I am sorry for that. We have discussed and defined roads, trails, and driveways. This presents as a singular issue, and I encourage the board to focus on the non-conforming use of the existing driveway.
Anyone else? Thank you, folks. I guess before we begin talking amongst ourselves and deliberating on this, we should take a vote on whether to accept any new evidence or not.
Sorry, it's hard to hear you.
No, that's okay. Did you hear me? Okay.
Just as a point of order, before you make that vote, the CEO submission that you had orchestrated with Mr. Larson has a lot of stuff in it that wasn't in the original record, so we're gonna have to parse all of that out if you decide not to let it in.
Such as?
The notice is a violation for the buildings that were put in, the building permits for those things. I'd have to go through it, there's a lot of stuff. That email from the MMA, very helpful to me, I think, but I don't think that it was originally in the record. There's a lot of stuff in the CEO submission that wasn't in the record, so. And you only get to that if you decide not to let in my little survey thing.
Mr. Lyons, what's your opinion on that?
Well, I can't say that I reviewed the former CEO's submission of the evidence versus what's in the record as the parties agreed to. But I do agree with Attorney Bear that if you vote to allow in new evidence, that would address the need to parse through all that. And again, if you do vote to allow new evidence, the board gets to apply whatever weight it wants to that evidence. So just by voting to allow in evidence, that's one step. And then your analysis is what weight do we give this evidence versus other evidence in the record.
But what I thought he was arguing is some of the things in Mr. Larson's memo is new evidence.
That is what he's arguing. So if
And
you
I'm
want
not
to-
sure I
He's
agree.
correct.
What's that?
He's correct about that.
But when was this memo? I mean, is this, I don't know that.
Oh, you didn't get a copy?
It was with the submissions back in October.
Yeah, back, way back, yeah. It's-
Yes, I got that.
Okay, so we need to make that decision. I think we have plenty to go on. I don't see where we need to accept any new evidence.
I personally don't think we should accept any new evidence. I just feel that we should go by what we have.
Would you like to make a motion to that effect, Ms. Scott?
Sure, good, if I may.
Yeah.
So if we were voting to not permit in any new evidence, then to Attorney Bear's point, that would preclude any new evidence that would have been presented in the previous code enforcement officers' submissions. Again, I can't tell you which ones are which, that's at this stage, but it would be thus any evidence that was provided by the former CEO's filing that wasn't in the record cannot be considered by this board in reaching its decision by that much.
And we're on our third CEO from the time this started.
Yeah, understood, but nevertheless, that was submitted by CEO Larson, so, the vote to prohibit any new evidence would mean prohibiting any new evidence that's submitted as part of the record. That being said, if you don't rely on any of the evidence provided by the former code enforcement officer in their October filing, then that addresses that issue.
Including what they said tonight?
No, not what they've said tonight. I don't believe either party, please let me know if I misspeak, cited to any of the evidence that was presented by Code Enforcement Officer Larson's filing. And depending on what evidence you point to in making a decision one way or the other, so long as it's not evidence provided by CEO Larson that's not in the record, then that just shouldn't be an issue.
So we're better off to accept new evidence.
So there's pros and cons to it.
So there's a catch-22.
Well, my position is you can vote to allow in the evidence that was submitted by both Attorney Bear and the applicant and the previous code enforcement officer, and then you can decide what to do with it. You can apply any way you want to it or none at all. So, you know, just because it's now also evidence that you can consider making your decision, doesn't mean you need to, you know, apply any weight to it. You can say, you know, code enforcement officer gave us this MMA memo, but we don't even, we don't think it's necessary to get to our decision. You know, that's really, but if you do turn to any evidence that, if you don't allow it in and then you can't turn to it. So if you'd like to turn to that evidence one way or the other, you should allow it into the record. Again, my position is you can allow it all in and then again, make your decision based on whatever evidence you want that's new or already in the record. That's within your discretion as a planning board.
So if this ends up in court again, would that evidence be able to be used in court?
Yes.
So we should accept.
So we should accept it.
So I make a motion that we accept new evidence.
I'll second.
We have a motion and seconded on the table to accept new evidence. Any discussion? Kind of on the fence with this, because I'm not sure. We've got volumes of material here. What is new evidence and what isn't? And do we need anything additional to make a decision?
What can we say up to this point? New evidence up to this point?
So what I would clarify is, we can think about the evidence in this case, in this matter, as kind of two buckets. Everything that was presented to this planning board up until the point of the last appeal that went through the court. And then since the court remanded, the parties and the former code enforcement officer submitted to you new argument, and in some cases, new evidence. So that's the other bucket, is the new evidence since the remand. No one here tonight, from other than just general comments, has provided any additional evidence than what was provided in the written submissions. So I think by voting to allow new evidence, in essence, you're voting to say we are allowing the evidence that was presented in the written filings since the remand, and that is also going to be evidence that we can consider making our decision. So that it's really just limited to what was filed since the remand, what was filed in October.
Wouldn't Mr. Bear's contention that the driveway is 502 feet be new evidence?
It is, yes.
Okay.
So that plan would be new evidence. Again, you can apply whatever weight you want to that evidence. But if you vote to allow new evidence, you vote to allow that plan, and that plan becomes a piece of evidence that you weigh. You know, they're advancing it in support of their argument that this is a road, not a driveway. There's other evidence, new and otherwise. I don't believe Attorney Pileggi has advanced any new evidence in supporting his contention that it's, you know, in essence, this is a driveway. So again, you're free to weigh all the previous evidence that one party cites to, and all previous evidence and new evidence another party cites to, and then you have to make a decision, which way you're going to go. So you're going to have to do that anyways, but now there's just another, seems to be the major piece of evidence you consider is also this new proposal. Again, you can apply whatever weight you want to it. You can apply whatever weight you want to the previous evidence. My 2 cents is you allow it all in, and then you apply whatever weight you want to it, and you make your decision.
How does that work? Do we have to parse everything out?
No, actually, in my opinion, it makes it easier. You just point to whatever you want that was either previously in the record or what's here tonight, and the next step will be your deliberation, and you're going to decide whether or not this is a road, a driveway, or a trail, and you're going to need to cite to evidence to support that decision. Both parties have provided you, helpful proposed findings and conclusions, which you can use as a guide, and they actually cite to specific record evidence. So again, you could say, this is all hypothetical, but if you end up saying, I think it is a driveway, then you could look to what the abutters have said makes it a driveway, and you can say, well, I think it is a road. Then you point to the applicant's evidence that they've said that it is a road, and that would include the new site plans. So you don't have, just because the new site plan is in the record,
We don't have to use it.
You don't have to, but you can,
It's
you know,
there
you
if
can
we
consider
need
it, it's in, reply whatever way you want to.
Okay, so we have a motion and second on the table to accept new evidence,
Yes.
correct? Any further discussion on that? Hearing none, I'll call for a vote. All in favor? Okay, 4-0. Okay. Ben, you asked before about, no,
Chair, good, I'm sorry. to interrupt.
that's a go, right ahead. Please, I interrupt.
Can we just need to clarify that the public hearing is now closed.
Okay.
and we're on to deliberation.
Okay, we're to close the public hearing. It's at 7 o'clock.
Close enough.
Okay, at 7 o'clock, and we're going to begin deliberations. Ben, you asked about non-conforming uses before.
Right.
Okay. So
I remember.
there was a bed and breakfast.
Yeah, and then after a year's period, the use would change back.
Resumption prohibited, okay? A lot, building, or structure in or which a non-conforming use is discontinued for a period exceeding 1 year, which in this case it was, or which is superseded by conforming use, may not again be devoted to a non-conforming use, except that the planning board may, for good cause shown by the applicant, grant up to a 1-year extension to that time period, which never happened. Okay, so that use is gone, okay? This provision shall not apply to the resumption of a use of a residential structure, provided that the structure has been used or maintained for residential purposes during the preceding 5-year period. So it has nothing to do with whether they wanted to do a campground or whatever. It was just for the bed and breakfast. And that was never, they never took advantage of that 1 year, so that use is gone.
So if the maritime zone was not there, we wouldn't be having this discussion on the road.
Probably not on the road, and I mean, I'm not going to go into detail, about the rest of the application. I don't know, Mr. Bear's contention is that we thought everything else was fine, but I can't recall exactly, so.
Chair, could
The
you
what?
clarify what section of the ordinance and what version of the ordinance you're reading from?
Oh, okay, it was, land use ordinance, Article 7E, non-conforming
Sorry,
uses.
is this the version that's effective as of May 13th, 2024?
You are correct. Was there anything else, Mr. Lyons?
No, that just wanted to confirm for the record.
Okay, okay.
Well, I spoke to Mr. Lyons because I just would want the court to understand that you were reading from an ordinance that was in effect in roughly 2002, when the period of time that this gentleman was asking about would have expired. It's not what the current ordinance says. That doesn't matter. This is 22 years later. That's what it said in 2001 or 2002. I was just curious which ordinance you were reading from. It's going to go that
Right.
effect.
I have no idea what the ordinance said in 2001. Any other discussion here? Opinions? Renee, you're way down there. Come on closer.
Well, I got everything all spread out here.
Oh, okay, okay.
She looks
See.
comfortable.
Okay, Mr. Lyons, do you feel that we should go point by point here?
So here's my 2 cents on how you proceed. You have, both parties have provided you proposed findings and conclusions. So, and obviously one party findings and conclusions reach one conclusion, and the other findings and proposed findings and conclusions reach the other. So I think what might be helpful for the board to kind of get themselves, oriented here, is you can take a look at the proposed findings from the applicant, and you can take a look at the proposed findings from the abutters, and see, and then you can discuss those proposed findings as far as how you, whether or not you want to adopt any of those. Before you do that, you can also have a conversation just generally, here's what I've heard, here's what I'm thinking. And then maybe that conversation will lead the board to say, well, maybe we're leaning one way or the other. Let's go take a look at the proposed findings that, that seem to support the way we're leaning right now, and see if that's a valuable exercise to work through that.
Does everybody have a copy of those 2 memos? One from Mr. Plaguey, one from Mr. Bear.
Is it in the stuff that,
So Beth, it was in the materials that were submitted in October. I believe it all was organized in a single PDF binder document that was provided to the board. As far as I have, the petitioners proposed findings are on page I think we're talking about page 9. I'm fine. Page 95. And it's a 2-page document. It says proposed findings of fact and conclusions. And then the abutters proposed findings are on page 116. And that is a 118, and that is a 3-page document.
You guys don't have them?
not in my packet.
We do have a copy machine.
Why don't we make a bunch of copies, where everyone has them, you guys can work them out. That would work out.
That's what I was going to suggest. It'll make it easier or quicker anyway. Thanks, Angie.
While you're waiting for Angie, if you want to, you can discuss the evidence you've heard tonight, or evidence you reviewed in the written submissions, or the evidence that's from the previous record, or we can wait to review those.
You guys want to wait to review it, or? Yeah, I figured you did.
Okay. Do you want to take a 5-minute recess, in case folks want to use the restroom or stretch their legs or anything?
We could do that. Take a 5-minute recess,
Okay.
starting at
7:10.
7:10. Hey, I didn't say that close. What's that?
Yeah, it seems like we're making copies. Okay.
She's making comments. Yeah.
Hey, Beth.
I know,
guys, let's
can't
not-
stop.
Let's not talk on recess, that's not part of this. Unless you could talk about, my grade.
How's that basketball game going?
Yeah. How's that?
Just started.
And how about those Commanders, huh?
They're about to get beat up by the
Yeah, the Lions are gonna kill them.
Very,
But it was quite a kick, though, huh?
Yeah, sure, you're just halfway between Detroit. Lions fans and the.
Many years ago, before you were born, and I graduated from law school, I came to Grand Rapids.
Oh, really?
Yeah.
Michigan State and Western Michigan.
My son's a university nurse, so his main coach.
Yeah, oh, yeah.
And I like to joke that they kept.
Yeah, he's fantastic.
Have you met him?
I did meet him.
He's one of those guys that's got that personality that's just really.
Yeah, they, the highest paid public servant or, public official.
Still not that much.
No, still. He's, whatever, we actually do have
I've heard from their keys change things up this year. Past years, that's funny, we've done it for years in a row, like the two finalists.
Oh, was it Cornell or Colgate?
I know last year.
That it?
Sometimes. It's tiny little school, so it's like once every few years.
Well, now we're, four little players,
Nephew is assistant football coach at University of Buffalo, and he says it's crazy with
Oh, yeah.
they just replace a team. If they don't like what they have, they go to the portal and just.
Well, every year, every player becomes,
Yeah.
which is.